I can't take it now. Okay, can you guys see the screen?
I can see a screen. Okay.
Okay. All righty. Let me do this other part. All right, I think I got us back on track here. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included in the partnership, we have the City of Houston's Department of Neighborhoods, and joining us, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Kimberly DK, who will be giving you the instruction and the information in regards to evictions today. So we both just had a lengthy little discussion about what's going on in the eviction, in the world of eviction, and what prevention measures can be taken. So we'll kind of get into that at the end of the presentation. But to give an introduction of the other partners, it also includes the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we all make up a month of service. And basically what the month of service is, it's the collaboration of all of our organizations. We come together on a monthly basis, offering a variety of different workshops, resources, and information relative to community empowerment, asset protection, asset building, and the maintaining of generational wealth. We know that there are a lot of communities that are out there that do not have access to a lot of information, to a lot of resources that needs the information, such as about evictions and knowing your rights and where to go to for assistance. So we decided to collaborate several years ago and come together in hopes to reach a larger audience and create a larger impact. And try to reach as many people as we possibly can. So the collaboration has been working very well. We've had to transition to the virtual platform where we used to be in person, and we're slowly trying to get back into the in-person presentations, but or even a hybrid presentation method where we're actually out in the community so that people can have can view the information, at least to still hear it. So if there are currently any workshops that we do not offer that you guys may be interested in, then please feel free to reach out to any one of our partners so that we can make sure that that your voice is actually heard. So we're asking everybody to complete the survey at the end of the presentation that you'll see that pops up on your screen. Kind of, just letting us know what's going on, what are you guys interested in, and so on and so forth. Do know that the information that we do present during our workshops are for educational purposes only. They are not to be considered legal advice. However, we do encourage you to reach out to any of our legal service partners if you do find yourselves in need of any civil legal assistance or, like rental or eviction um, issues and things like that that you may be facing or know of someone that may find this information to be beneficial. We do also ask that you forward it and pay it forward to someone else that could also utilize it. Know that on this virtual platform, we are recording this session as well as broadcasting live on our social media platforms. So we want to try to protect your privacy as much as we possibly can and ask that you do engage and that you do, ask questions, whatever it is that you may have, by typing your question into the chat or unmuting yourself and, speaking with the presenter directly, or, typing it into the comment section if you're following us on our social media pages. But know that, again, it is a live session. We are on social media. So do keep in mind that as you're asking your questions. So we try to ask you to keep your questions to be as general as you possibly can so that you don't divulge any personal detailed information about yourself or any particular circumstances that you're facing currently. So do keep that in mind. But again, we do encourage you to be interactive. We know that eviction is very serious. We know that, some people are kind of at different phases or what have you. And we know that it's crucial that things are done in a timely manner as it relates to eviction. So we understand the sense of the urgency. But with that being said, we're going to move on into the introductions and get ready to get into our presentation. So we want to thank you guys for joining us this afternoon. If you're new to the channel, welcome. If you're coming back and you've been here before, we thank you for continuing to support the A Month of Service collaboration, and we look forward to servicing you all again at a later time as well. So I'm not sure if Cecile is at a place where she can speak. I know that she was getting ready to join in, but we'll definitely make sure that she gets an introduction in before we end the presentation. But in the meantime, Ms. Kimberly DK, we want to go ahead and have you introduce yourself, and we're going to go ahead and get started.
Thank you, and thank you for having us. My name is Kimberly DK. I'm an attorney with Lone Star Legal Aid's Eviction Right to Counsel unit. Let me go ahead and share my screen. Okay.
Okay.
So today we're going to be talking about your rights as far as eviction goes, but for some background on Lone Star Legal Aid, Lone Star Legal Aid is a 501c3 nonprofit law firm with the rich and deeply respected history of advocacy on behalf of low-income and underserved populations, beginning with the Houston Legal Aid Clinic in 1948 and East Texas Legal Services in 1977. In order for us to help, you must go through an application process. You can apply 24 hours a day and 7 days a week by applying online. You can also apply by calling the toll-free number listed for every office that serves you. Lone Star Legal Aid serves 72 counties in South Texas and a few in Arkansas. So you want to look up what might be in your area and call that toll-free number. Every Lone Star Legal Aid office has a designated time for non-emergency applications to be taken over the phone. Due to COVID-19, we're not currently scheduling in-person application appointments. However, several of our offices are open. Most of them are open. So if you have any, if you want to come in and do an application in person, you do have that ability. Again, look up your local legal aid office, and you can apply online at www.lonestarlegal.org. So I'm going to go over our agenda. First things first, we're going to go over leases, how to terminate the lease in different ways leases are terminated, a notice to vacate requirements, and then we'll go into the forcible detainer suit, also known as evictions. We'll talk about appeals, how those work, how to go through them, give some information about public housing and subsidized housing cases, lockouts and utility shutoffs, and your security deposit. And again, this is for educational purposes. I will not be giving any legal advice, so don't take anything as legal advice. First things first, leases. Texas allows for both verbal and written leases. A lease is an agreement between a landlord and a tenant that establishes the rules regarding the use and occupancy of a dwelling. So if the lease is for a term longer than a year, the agreement must be in writing. However, if you're on any month-to-month contract or month-to-month agreement, that can be verbal. And your lease is a contract, which means both parties have a right to put in what they want and how they want the agreement to go. Yes, you might run into larger apartments that have very standardized leases, but always remember that you do have the ability to negotiate the terms of a lease. And so when you're going through everything, read it carefully. And if you have any questions or want to make any edits, be sure to discuss that with your landlord. Now, once signed, you have a right to a copy of your lease. Within 3 days of the lease being signed by all parties, the landlord must provide you with at least one copy of the lease. Now, this is a right. This is in the Texas Property Code. So if you don't receive one, you want to ask for it in writing, send your landlord an email or send them a letter letting them know, hey, I never received my copy. Can I have it? And they are required to give it to you. So if you have a problem getting your lease, make sure you express the fact that you do have a right to a signed copy. Now, you're going to want to know your lease terms and read over your lease and make note of the important clauses. So some of the important clauses that we've highlighted is you want to know how much your monthly rent is, when and where you're going to make payments. You definitely want to know if there's going to be any late or returned insufficient fund fees, and how your payments are applied. So most departments are going to say if you have any additional fees on your ledger when the next month comes up, even if you pay your rent in full, they can apply that to any back owed fee or utility that might be on your ledger. And so that month you might think, oh, I gave you, the rent. Why are you saying I'm behind? It's because they applied to something else. So you definitely want to make sure you understand how those are applied and be very clear about how to deal with those issues if they may arise in the future. You're going to want to note your initial lease term. And if you're on a month-to-month term, so your initial lease term is the first 6 months, the first 12 months, or whatever term you guys agree to, because again, a lease is a contract. So you're going to want to know what your initial lease term is, because certain things can and cannot happen during that term. And then after that term, if things roll over into month to month, you're going to want to know what that looks like. Do you need to give notice? Will they give notice that your lease is going to renew on a month to month basis? Will your rent go up if it's month to month? Will you have a month to month fee? All of that needs to be outlined in your lease. So make sure you know those terms and understand them well. You're going to want to make sure you make note of your community rules and policies, any signed addendums. If you have any HUD or Houston Housing Association agreements, you're going to want to know exactly what that is, what your portion is, any type of renewal requirements, any notice requirements. You're definitely going to want to know exactly what those are and get a copy. You're going to want to know if you had any concessions. If you're on a move-in special, okay, sometimes a move-in special might end if you miss your first payment. You're going to want to know that so that next month, if you get an extra fee or have any problems, you'll understand and know what's going on and how to tackle it. Another clause that you need to make sure is in your lease is acts of default. Things that might appear as acts of default are failure to pay rent, a material breach of the lease, early termination, or holding over. So you're going to want to know exactly what is going to be considered a breach. If you fail to pay rent, obviously that's non-payment. You're going to give rise to an eviction. But something maybe like multiple violations of your community rules and policies, you're going to want to understand that what might look little to you, your third or fourth notice might end up with an eviction notice. So you're going to want to make note of exactly what the community rules are and make sure that your family, your lifestyle, or the people who are moving into that apartment complex can follow those rules. And we'll talk about more later. You also want to know all your timelines, notice of default, notice to vacates, any notice of lease renewal or non-renewal. You're going to want to make sure you know how you're going to receive those. If they're always going to send it via snail mail, you're going to want to make sure you have a mailbox key and you check it regularly. If they're going to send things through your portal, you want to know what that is and how often to check. So those are important lease terms to look over, but of course, read your entire lease, understand exactly what you're signing up for to make sure that you don't end up accidentally breaching it and facing an eviction in the future. Now, when it comes to terminating a lease, there's several ways that this can happen. Now, after the initial lease term, both the landlord and tenant have the right to terminate the lease with proper notice per the timelines agreed to in the lease. Now, notice of lease termination and non-renewal, your lease will contain language regarding the timeline of termination and when notice must be provided by either party. Now, if you are given a notice of lease termination or non-renewal and you fail to leave after you've been told, hey, we're not going to renew, your lease will end on the 30th of this month. If you fail to leave by the 30th, you're considered a holdover tenant. And being a holdover tenant can be grounds for you to face an eviction lawsuit. Now, except in very special circumstances, you cannot make your landlord renew your lease. So if you get a notice of non-renewal, you go to the office and talk to your landlord, and they say, no, we want to do something else with the unit. You have to take that notice seriously and make a move. So just like your landlord cannot make you renew your lease, if you decide to move and you want to find a different place to go, you have to also, you can't make your landlord can't make you stay any more than you can force them to make you stay. Sorry, something popped up on the screen and caught my attention. So to repeat myself, You can't make your landlord renew your lease, just like your landlord cannot make you stay. So if you get that notice of non-renewal or a notice of lease termination, take it seriously and begin to make your plans. Now, if you terminate the lease during the initial lease term, this is going to be deemed an early termination of the lease. And if you do so without consent, you may be subject to certain fees and penalties. So you definitely want to make sure when you're reading your lease, you understand if there's any reason why during that first year, first 6 months, or whatever timeline you have that you need to leave, you notify your landlord and get consent first so that you understand if there will be or won't be any penalties, and so you can deal with that ahead of time instead of on the back end. Now, in specific circumstances, a tenant can terminate the lease and avoid certain liabilities. And your lease may or may not be required to give notice of these statutory rights, and I'll let you know which ones they must notify you of and give you instructions. So I'm not going to go into detail on all of them. I do have the Texas Property Code numbers here if you need to look them up. But if there's family violence in the home, or if there's certain sex offenses or stalking that happens, you can provide your landlord with information that will allow you to terminate your lease without facing any penalty. And these can't be waived by the tenant. So if anyone says, oh, you signed a lease that says no matter what, you have to stay through it, these cannot be waived. So you definitely want to reach out to an attorney if you do end up in one of those situations. Of course, in tenant's death, you can avoid future liability, but past due obligations such as unpaid rent or any damage beyond wear and tear are still recoverable by the landlord. So notice in the lease is not required, but if you do end up dealing with death of a relative and they're saying, oh, there's an acceleration clause and you need to pay the rest of the lease, no, you need to reach out to an attorney to help you understand how to avoid those obligations. And then certain decisions related to military service can give rise to you being able to provide your landlord with information to terminate your lease early and avoid liability. But in order to terminate your lease, vacate the premises, and avoid liability, you need to review each statute above. Each statute will tell you exactly what documentation needs to be provided to your landlord in order to trigger these rights. So you definitely want to reach out to an attorney if you deal with any of these issues, and be very clear that you just want to understand what you can do to terminate your lease in the event that any of these things happen. Other situations where you might have a right to terminate the lease early is that in a casualty loss, if the premises is made totally unusable for residential purposes due to a casualty loss, and the loss is not the result of the tenant's failure or fault or negligence, then this Texas Property Code provides tenants with the right to terminate the lease. The Texas Property Code 92.054 also provides landlords the right to terminate the lease once the property becomes totally usable. So the right belongs to both the landlord and the tenant and to be able to terminate the lease for a total casualty loss. Now, if the premises are made partially unusable for residential purposes due to a casualty loss, and the loss is not the result of the tenant's fault or negligence, the statute provides the tenants the right to petition certain courts for a reduction in rent. So you can file a lawsuit saying, if I lost my second bedroom, the ceilings caved in, the carpets have been ripped out, and they're still working on it, and I only have one room, you could be able to say, a court can determine if the place is 50% usable, they reduce it to 50%, for example. But a landlord does not have the right to terminate the lease just because the premises is partially unusable. So you'll definitely, so the right doesn't go both ways in that situation. However, the code and the clause can be waived or altered through agreement in the lease. And again, in order to terminate your lease, vacate the premises and avoid liability, review the statute, and so that you understand what documentation needs to be provided to your landlord in order to enforce these rights. Now, the lease can also be terminated because a breach or default occurred. Now, a breach of a lease is any violation of the lease terms, conditions, rules, or other provisions, and your lease will also tell you what a breach is. And again, if you are working with maybe in an arm's length situation or a verbal lease, you also want to make it very clear on what a breach is, because just because it's a verbal lease does not mean that you cannot establish these terms so that you understand what is your responsibility, what's your landlord's responsibility, and what could, lead to an eviction in the future. Now, common defaults by the resident terms are failure to pay rent by the date stated in the lease, repeated violation of community policies, unauthorized tenants, criminal activity by tenant, occupant, or guest, or holding over. If a breach of the lease occurs, the landlord must provide proper written notice before filing an eviction. And we'll get more into that soon. But if any of these breaches occur, that starts the crack in your lease and will open you up to liability and open you up to possible evictions. So you definitely want to be aware and avoid those. Now, in certain circumstances, withholding rent might seem like a good idea, but it is a self-help remedy that is very rarely done correctly and will set you up for an eviction lawsuit. So don't do it. So even if you feel like your landlord is breaching a part of the lease and not making a repair or something else, the way to enforce it is not by withholding your rent. So Texas law requires that rent be paid in full and on time as it comes due. Withholding the rent prematurely could subject you to an eviction for non-payment of rent. So even if you're saying, I have the money order, I have the payment, it's ready to go to you, but that's not enough. You still can be evicted for non-payment of rent. You must be current on your rent in order to maintain your rights. So once you fall behind on rent, including not paying on purpose, your landlord doesn't have to fix your apartment. So that's the other part. If you withhold your rent thinking that it's going to make them repair it in order to get their money, the opposite is true. Failure to pay rent triggers a law that says your landlord no longer has to make repairs. So you definitely, if you want to enforce your rights, continue to be current on your rent. And if you're having issues obtaining repairs required under the lease or repairs that threaten the health and safety of an ordinary tenant, then you need to send your landlord a request in writing via certified mail and then contact a legal professional. There are several steps between requesting a repair and obtaining your right to withhold rent. So it's best to contact a professional to help you get through it if you must, but definitely do not withhold rent simply because an issue has arisen. You definitely want to pay your rent and then go to someone to ask what rights and you have and how to enforce them. So in special cases, what if full and timely tendered rent is refused? Your landlord is not free to refuse properly tendered rent pursuant to the lease agreement. So note that landlords may refuse rent if it's late, only a partial payment, or if the lease has been terminated. But landlords may also determine the manner in which amounts are paid. So this goes back to not just knowing how much your rent is, but how, when, and where your rent must be paid. So if your lease says that the landlord must be paid through this portal, but then before rent is due, you're locked out of the portal, your landlord's not allowed to do that and then claim you didn't pay your rent. So tenants who have had timely rent refused should do the following. Review your lease and current ledger to make sure that the amount offered covers rent and all other fees due and that the payment is offered in a manner consistent with the lease. So that goes back to knowing how much you owe, knowing how much fees are assessed if your utilities are on your ledger, and then making sure that you're going through the correct portal. So if they say you must pay by money order, don't try to give them a credit card and say that they're rejecting rent. You still have to kind of follow what your lease says and what it requires of you. You want to document the date and manner of the payment, document correspondence with the landlord. If you are, and this is a conversation you can have over the phone, but make sure you get some type of writing if possible. Asking the landlord, hey, it's the first. I have my money. This is the amount that showed. I'm not able to pay. What's going on? Make sure you have that correspondence and keep hold of it. You definitely want to keep the payments or funds for for the payment available. So you don't want to spend the money. Don't say just because they rejected it, you can spend it. No, hold on to it and continue to offer the rent in full and on time for future months. And if anything, if problems continue to arise, or if your landlord threatens to evict you, for example, for non-payment, definitely contact an attorney for assistance. So in order to begin the eviction process, proper written notice is required. So this will start with a notice to vacate. And a notice to vacate can be based on any breach that we discussed earlier, non-payment of rent, violation of community rules, etc., but it has to be given to you in writing before they start the eviction process. So the Texas Property Code requires proper delivery of the notice. So it must be in writing, give at least 3 days, and unless the lease allows for a shorter period of time, and it must be delivered properly. So proper delivery is in person, hand delivered. So you look at the landlord looks at you, and you get a sheet of paper handed to you. That's hand delivery. They can also send it regular mail, registered or certified mail. So if you know you're in a situation, you definitely want to keep an eye on your mailbox, or they can post it to the inside of your front door. As an alternative, in an envelope affixed to the outside of your door, you can get a notice this way. You definitely want to take a picture of it before you take it down, because the envelope itself must have specific language on it. And the landlord must also prove up why they wanted to place it on the outside of your door. Once it's placed on your door, your landlord must also mail a copy to the tenant by placing it in the mail before 5 p.m. So you definitely, again, if you know you're dealing with a situation, you're a little behind on rent, definitely want to keep an eye out on your mailbox, as your landlord must also still send it via mail. Excuse me. Now, in certain situations, covered properties are required to give a 30-day notice to vacate. Now, this is under the CARES Act, which certain areas of it are still in full effect. So if the property participates in a covered housing program under VAWA or gets some sort of federal funding, this means public housing, Section 8 housing, housing choice vouchers, project-based housing, rapid rehousing, the list is very long. If either two of those exist, or the complex has a federally backed mortgage, then your landlord is required to give you a 30-day notice. For larger properties, some of this information is readily available. However, databases are not really being updated anymore. But there are different ways you can find out. So you'll definitely want to check your real property records, request the information through the discovery process, or just, notify, if you reach out to an attorney, that you believe that they might have a federally backed mortgage, or, even if another tenant might be under a voucher, for example, then they would be a covered property, required to give you 30 days notice. So, and this is not just for large complexes, single family homes, duplexes, mobile homes, etc. If the property is covered, then they are required to give you 30 days notice, even if the lease allows for shorter. So evictions are also called forcible detainer suits, and they are governed under the Texas Property Code, Chapter 24. The eviction lawsuit's primary focus is to deal with the right to possess the property. So that means your landlord's basically bringing a lawsuit saying, I just want my unit back. I just want my house back. And so that's what the baseline of an eviction is about. So the main elements that the plaintiff landlord must prove is that they own the property, or they have a right to ask for the property back. So they must prove that the owner or the leaseholder, that a breach of the lease has occurred, or termination at the end of a lease term. They must also prove that they gave proper notice under the Texas Property Code. Like we discussed, they have to deliver it properly, and it must have certain language, and that the defendant refused to leave. So if you gave notice, hey, can you leave in 3 days? The only way they can start the lawsuit is if you didn't leave in 3 days. So you definitely want to pay attention to when the eviction lawsuit's filed. If it's filed on the second day, for example, obviously they can't prove that you refused to leave by the date that they filed it, because the third day hasn't come. So you definitely want to pay attention to that, pay attention to the dates on any of the paperwork you're given, and go from there. Now, when the breach of the lease is non-payment, then the landlord can add a claim for back due rent amounts. However, the landlord can only ask for base rent. Late fees, past due utilities, or other sums due require a separate small claims lawsuit. So if you receive a eviction citation and the number seems lower than what your landlord was previously alleging you owe, that is usually because the lawsuit can only deal with back due rent amounts. So definitely want to keep that in mind. If you do want to stay and you want to clear your ledger and stay in the unit and work with your landlord, then it's going to be the amount that's on your ledger, not necessarily the amount that you see in your eviction citation. You do have a right to request a jury trial. The request must be timely and there is a fee. But even in the JP court cases, you can request a jury trial. Now, trial and justice courts. Justice courts use simplified procedural rules and do not have to follow the rules of evidence. So they can differ greatly from court to court. So if you've dealt with something before with a different judge, you could have a completely different experience with another. So you want to make sure you arrive on time and have everything you might need for trial. Some courts will call dockets while others have you check in with the clerk. So you don't want to risk getting a default by showing up late after your name is called. So definitely want to arrive on time. Some judges give instructions on how the court works prior to calling of the cases. Some don't. At trial, judges generally begin by hearing the plaintiff's case first and then giving the defendant an opportunity to respond. So be prepared to answer the judge's questions or to provide evidence of your defense. The trial can only be reset by motion of the plaintiff or if both parties agree to a continuance. So when you go to court, don't assume that if you tell the judge your story or explain yourself that the judge is going to be able to give you the 30 days. Only the landlord or through agreement can reset the trial. And at the end of trial, the judge will issue a judgment in favor of one party or dismiss the case. And always get a copy of the judgment for your review and for your files. So some courts might ask you to stay after the hearing to get a copy. Some of them will mail it to you, or you can check online for some courts, but you always want to know exactly what the judgment says, what your timelines are, and you want to keep a copy for your files, especially if you get a dismissal. And as always be respectful of the judge, the court staff, and the opposite party. And this also includes reading your citation to understand what your courthouse that you're going to, what the rules are, so that you are dressed appropriately so that you're not kept out of the court and may receive a default judgment for that as well. Now, some judges encourage settlement agreements between the parties or provide resources to facilitate settlements, such as standard settlement forms, or they might have mediators in the courthouse that you can request to speak with that can enter that agreement. Now, a settlement agreement requires both parties to agree to specific terms, although the parties determine what those terms are. A good agreement will clearly define the actions to be taken by both parties. So like the tenant agrees to leave by a specific date, landlord agrees to dismiss the case if tenant moves out. If the court provides a standard agreement, always review it to make sure it reflects what the parties negotiated. So again, just like I said with the leases, it might seem like a form that no one can alter. Start scratching things out, fill in the blanks, write in the margins, just make sure it's initialed and signed and it'll be binding. And a settlement must be in writing, signed by both parties, and should be filed with the court. An informal or unwritten agreement between the parties is not enforceable by the court. So even if you guys had a settlement agreement before arriving in court, you want to get that in writing so you can provide it and file it. A settlement agreement may involve both parties giving up rights and may impose a settlement agreement may involve parties giving up rights and may impose penalties if a party fails to comply with the agreement. So you always want to know what you're agreeing to before signing the agreement and make sure that you will be able to comply with the agreement before signing. Now, if you're unsuccessful in the JP hearing and judgment has been entered in favor of the landlord, which means you'll have to move out, you do have a right to appeal the court's decision. Now, in order to do that, within 5 days of the court date, you can request an inability to afford court costs and fees form from the clerk, fill out the form completely and under oath, and return it to the clerk. If you do not appeal, you must vacate the unit within those 5 days, or the writ of possession can be issued. Within 5 days of filling out the inability to afford court cost form of the IFP form, if you are being evicted because you did not pay rent, you must make 1 month's rent payment into the court registry. So you'll be returning back to the same court to make that rental payment in order to avoid the writ of possession. Once that payment is made, your case will be transferred to the county civil court at law downtown and assigned to a court. You will receive paperwork in the mail, so check it regularly. You do not need to file a separate answer if you filed the appeal with the IFP form. Excuse me. Non-payment of rent cases filed with an inability to afford court cost form. If you file and your case is delayed, let's say another month, monthly rent payments must be paid into the registry as the sum becomes due. This is usually on the first of the month, and failure to make the rent payment can cause you to lose possession of the unit, even though your case will still go to trial. So, let me go back real quick. I want to just give a quick definition if anyone doesn't know what the writ of possession is. So a writ of possession is the order that can be purchased after a judgment is made that says that that can be given to the constable in order to remove you and your property from the unit or the home. So once the writ of possession is requested, the constable will give you 24 hours to move. If they return and you're still there, they can move out your property. So in order to avoid that writ of possession being available to the landlord, that's why these payments will be due into the court registry, so you maintain possession. And when in county court, your case will be heard from the beginning, which is called what we call de novo. So anything that happened in the JP courts is going to be wiped away. And so everyone must prove their case up from the beginning. And so that includes the landlord and the tenant with their defenses. The county court uses formal rules of procedure and evidence. Justice of the peace courts are not courts of record, so there's no need to tell the judge what happened last time. However, you want to pay attention to what your landlord is doing in court, because they may have to start all over and prove up their case. You want to, you can get a sense of what evidence they have or don't have in the JP court, and make sure that you ask them the right questions, or make sure that they have the right testimony and evidence when you come to the higher court. Because in the higher court, the landlord must prove up their case with testimony and evidence. They aren't just going to be able to come and say, this is what I want. Now, if you are unsuccessful in county court and a judgment's issued for the plaintiff, you will have 10 days to pay the appeal bond. However, the writ of possession can still issue in 5 days in certain courts, by certain requests as well. The cost of an appeal from county court is usually 10 times the monthly rent due in a lump sum. And also some courts will allow for an immediate writ of possession to be requested and issued after the trial if you don't make your monthly payments. Now, also, if you're unsuccessful in county court, if you can appeal, or you don't have cause for an appeal, you do have to move out within those 10 days, or the writ of possession will issue. Now, some special cases like public housing and subsidized housing. Public housing and subsidized housing programs, including Section 8 Housing Choice Voucher and low-income housing tax credit properties, have additional termination requirements. The requirements are spelled out in the HAP contract and federal regulations depending on the program. Evictions involving public housing beneficiaries may also involve the termination of housing benefits. Public housing beneficiaries are covered by CARES Act protections. Public housing beneficiaries and non-payment of rent appeals are only responsible for paying their portion of the rent into the court registry. If the court orders a full amount of rent to be paid into the registry, then the tenant may contest that order within 5 days. So, so public housing and subsidized housing situations, you're definitely going to want to make sure you get copies of any addendums you sign and any HAP contract that might be in your file so that you understand exactly what must be done in the event that you breach your lease and eviction has begun. If you are on public housing or subsidized housing, a 30-day requirement, a 30-day notice is required under the CARES Act. And again, if you want to make sure you read your citation, read your order, if a judgment is issued against you, to make sure that it's very clear if your rent is subsidized, so that if you do want to appeal, you are paying the proper portion. But also you want to make sure it's noted that your rent is subsidized, so that the landlord proves up their case to make sure that they gave all the correct notices and followed all the correct procedures based upon the type of housing termination requirements, depending on what kind of program you're in and what those termination requirements are. The terms and tenant protections differ between programs. So if you're receiving public housing benefits and are facing termination or eviction, we encourage you to seek legal assistance. So what else might happen when the lease is breached? A lot of people might experience a lockout or a utility shut off, which may or may not be retaliation, may or may not be allowed under the lease. Now, your landlord cannot intentionally excuse you from your unit or home via lockout unless it's for bona fide repairs, construction, or an emergency, removing contents abandoned by a tenant. The tenant is behind on rent, and the right to change the locks is in the lease, and proper notice has been issued, or they have a judgment allowing them to do so. Your landlord also cannot intentionally interrupt your utility services unless there's bona fide repairs, construction, or an emergency, or the shutoff is authorized by the Texas Property Code, and that it's strictly followed. So again, in some situations, you might be able to be locked out. For example, if it's in your lease, proper notice has been issued and you're behind on rent. However, you will never be able to shut off utilities simply because someone's behind on rent. So you definitely have rights to get these problems fixed in the event that you are illegally locked out or if your utilities are legally shut off. Even if you are behind on rent, just make sure you understand, even if you are behind on rent, your landlord is not allowed to lock you out without the proper, without the right to and find the right notice, or to shut off your utilities. So you have access to judicial remedies if your landlord intentionally and illegally locks you out of your home or shuts off your utilities. These are called ex parte suits. If you're locked out, it's going to be a writ of reentry. That's the lawsuit that you'll be seeking. And if you are dealing with utility shutoff, it'll be requesting a writ of restoration. You must file the lawsuits in the precinct where you live. If you cannot afford to pay the court costs, you can file your petition with an inability to afford court cost packet to help waive the fees. Now, when you've been locked out, I'm going to go through how to deal with these ex parte lawsuits. So when you've been locked out, your landlord is required to let you back into your unit once the request has been made. And they must do so within 2 hours of making that request, regardless of the time of day, and they cannot demand any payment in exchange for the key. And this is ruled by Texas Property Code. So if your landlord fails to let you in and you remain locked out of the unit, you can seek a writ of restoration via lawsuit. And that lawsuit can be filed stating the facts of your case under oath in the precinct where your property lies. So if you're in precinct 5, you're going to want to either go to precinct 5-1 or precinct 5-2. And each precinct has 2 for you to choose from. Once filed, the case will be set for an ex parte hearing, which means you do not need to serve your landlord prior to this hearing. And if the judge agrees that you were illegally locked out, you'll receive a writ of reentry ordering your landlord to let you into the home. That is a document that you must then serve on your landlord in order to get them to let you back into the unit. Now, you do have a right to damages if any arise. They can be recovered It'll either be a civil penalty of 1 month plus $1,000, actual damages or expenses, court costs, and reasonable attorney's fees, less any delinquent rents or other sums. There is also an option to terminate the lease, if you want to. When the utilities have been shut off and disconnected illegally, you can file a lawsuit in the same manner by filing for a writ of restoration in the precinct where your home lies. This case will also be ex parte, which means you don't need to serve your landlord prior to the hearing. If the judge agrees that utilities were disconnected illegally, you'll receive a writ of restoration ordering your landlord to restore the utilities, and then you must serve the writ on your landlord. Damages in a writ of restoration suit, you can recover actual damages. So if they turn off the water and you had to go and fill gallons or had to get a whole bunch of water bottles because you have to take care of your family or to bathe or anything, you want to keep those receipts because those are considered actual damages. You have also, you can recover 1 month's rent plus $1,000, reasonable attorney's fees and court costs, less any delinquent rent or sums due to the landlord. Now, the security deposit is a completely separate issue. So that's just something we want to note so that you understand security deposit is what you pay to make sure your landlord would have something there if there's to be any wear and tear in the unit or any fees, for example, but it's not tied into your actual rent. So your landlord may keep and deduct from the security deposits amounts for the damages or charges for which the tenant is illegally liable under the lease or as a breach of the lease. Your landlord has an obligation to refund the security deposit on or before the 30th day after the tenant surrenders the unit. So if you are still in the unit, if you're still on the premises, then you can't consider your security deposit until you move out. Now, your landlord cannot retain any portion to cover normal wear and tear. And if your landlord keeps all or part of the security deposit, they must send you a written description and itemized list of all the deductions, unless the tenant owes rent and there's no controversy concerning the amount of rent owed. So when you move out, that's when the clock starts. So once you return the keys, once your landlord has been notified that you moved out, that's when your security deposit timeline begins. If your landlord deducts anything, they must give you an itemized description. And so you must give your landlord a good forwarding address in writing so that they know where to send this information to. But again, this is very separate than rent. You're definitely going to start demanding the security deposit after you move out. And if you have any issues with the security deposit or with any deductions, then that'll be a separate suit, a separate lawsuit. But that is something that you can go after and you can argue. So you'll definitely want to take pictures of the unit as you move out, get videos of the unit, and definitely get some type of written confirmation of when you returned your keys. So some additional tips is to get ahead of the problem and talk to your landlord as soon as an issue arises. This is what I was discussing with Ms. Murray earlier. Sometimes a lot of us now pay our rent via our online portal, and some portals, let's say, don't allow you to pay less than the amount owed. If you know you only have $600 of your $1,200 rent, go to your landlord first and say, hey, this is what I have going on. What can I do? Can I give you this $600 now and enter a payment plan? Of course, get it in writing. Any agreement you have that's different than what your lease says, make sure you get those in writing. But get ahead of it and say, okay, if they're not going to accept partial payments, then can you give me a little bit more time to move? If I give you the $600, can I have 2 weeks? Something, but you definitely want to get ahead of the problem. Evictions are lawsuits, and therefore they do show up in the public record once they're filed. So it's easier to avoid a lawsuit ahead of time than afterwards. So you definitely want to talk to your landlord or even just talk to local organizations, contact an attorney if you're feeling nervous, but get ahead of the problem. That's first things first. Rental assistance may be available in your area, so check local organizations or churches. And if you're having issues with the condition of the unit, pay your rent first to maintain your right to the repairs, and then contact someone for help. And that is the end of my presentation. We do have some online resources. You can visit us at lonestarlegal.org. You can also go to texaslawhelp.org for information. I forgot to update the email, but if you have any questions, my email is kdike@lonestarlegal.org, and you can always reach us at one of our phone numbers. Our Houston office is at 713-652-0077, or our toll-free number is 1-800-733-8394. Well, I'll leave that up in case there's any questions.
Sorry, I was talking. I didn't realize I was still on mute. Can you repeat your email address so I can put it in the chat?
Yes, it's KD like diamond, IKE @lonestarlegal.org.
Okay, so for those folks that are joining us as well, the contact information as well as the link to apply for services for Lone Star Legal Aid and other resources that and links and things that were mentioned throughout this presentation will be emailed to everyone following the presentation, along with a recording in case you end up joining us a little bit later so that you can go back and hear the beginning. Or if you know of someone, again, that could find the information to be beneficial as well, for you to share it with them as well. So there were only a couple of questions that I had that were emailed in advance to me.
Okay.
And I'm going to go over those. And I know that there were a couple of other questions. So what exactly is like the time frame from beginning to end, assuming that no one, responds to an eviction notice to vacate and things? What's the timeline for an actual eviction from the time you receive notice to the time you must exit the premises?
So it depends. So once you get notice, depending on if it's a 3-day, 10-day, 30-day, that starts that timeline, right? So if it's a
That's the
3,
notice to vacate, right?
correct, the notice to vacate is what the initial timeline. So depending on your lease or the law, that'll tell you that's the first amount of time. You don't have to self-evict during that time if you have nowhere to go, you can wait for the eviction process to start. But that'll be
Explain what self-evict means.
like moving out ahead of time. You do have a right to wait for the entire process to be completed. And so if you have nowhere to go and you're unable to reach an agreement with the landlord, then you can wait for the entire eviction process to be completed. So once you file an eviction, I believe the law is 21 days that the case must be set within. So once the case is set within those 21 days, depends on your court and your court's docket, of course. You'll go to trial. On the date of trial, if you win, you'll get a judgment. And if nobody appeals, then within 5 days of the judgment, the landlord can request a writ of possession.
So that's roughly 25 to 30 days.
Yes.
Okay. So I'm just trying to get the timeline in order just so people understand that the eviction notice to vacate, or I'm sorry, the notice to vacate is not the actual eviction itself. So you
Correct.
have rights in between that time, or something that you could do that you don't necessarily have to self-evict, like you said, and then that means you only got 3 days to actually leave your property.
Correct. So,
Okay.
but I would say once you get that notice, yes, let the let the feelings get over you, let them wash over, and then get back into gear and go and talk to your landlord. Figure out what can be done. Like I said, if the process is already going to take 30 days from them to get the property back, you might be able to ask them, I can be out in 30 days. Can I give you the partial payment I have? Or can we discuss any lease violation or, to avoid that filing? So yes, you'll definitely want to get that notice, make sure it's the proper amount, and go talk to your landlord in order to get ahead of the problem.
Okay, another question here. Um, Concerning paid rent and a lease that is now month to month. And what happens if the landlord is not letting a person get access to their property, even though the rent has been paid? and there is no lease there. It's now a month-to-month tenancy.
If it rolled over to a month-to-month tenancy, if that was allowed in the lease, because it depends on what the lease states. Because either it rolled over automatically, and so they either it rolled over automatically, which means their rights under the lease remain, or if it terminated immediately, they might not have those same amount of rights. And so that's what's going to depend on if they need to file a lawsuit for a lockout or conversion. So
But if they paid the rent and it was accepted, then
if they paid the rent and it was
there's no
accepted for the same month, then they need to contact someone to assess their lease and see what the next steps are, because they should not be allowed to they can't lock
not
you out.
have
That's essentially a lockout. It's essentially a legal lockout. And so if you have paid rent, you have proof that they paid it, then that would give rise to an ex parte lawsuit.
an ex parte. Okay. What is conversion?
Conversion is a legal way of saying someone, let me look up the legal definition, how I can explain it.
So is that way when the lease ends and now you converting to a month-to-month, it's that process?
Oh,
Or
no, I mean like
no.
conversion like theft.
Oh,
Yeah.
the theft being the taking your rent and then not giving you access,
And holding your property hostage.
holding your property hostage. Okay.
Mhm.
So you looking that part up, or is that what?
Yeah, because I'm like, in my head, I don't argue it enough because it's not a part of evictions, but yes, conversion, there could be damages for not having access to your property, for example. So that's where it would come into. So if they've interfered with your use of your property, for example, then that can be considered a conversion claim. Like I have my laptop inside and I wasn't able to use my laptop. So you interfered with my personal use of my property.
Gotcha. So that's kind of bordering on criminal at that point then. So, or is
Yeah,
this civil?
yeah, a little bit of both.
So get an attorney.
Get it? Yeah.
Get an attorney.
Yes, yes. That's what I said. By that point, if you have paid rent and you're being locked out and you have property in there, it's definitely into first file your lawsuit to get back into your property, which would be that writ of reentry, and then seek additional legal advice in case you have an affirmative claim for those damages of actual damages and 1 month's rent, all those things.
Can an eviction be sealed or removed from your record?
In the public record at this time, no. There's no legal way to do it. I think some courts might, depending on what type of agreement is entered by the parties, but there is no law that you can point to that says your case will be sealed or made confidential.
Okay, sorry about that. Somebody was knocking at our door. All right, let me make sure I got all the questions here. And from what I gather here, I'll say, can my landlord tow my vehicle if I'm being evicted?
Oh, and I used to have a slide on this. If your car is registered and as long as your lease, if your car is registered, running, has its permits and everything proper, your car cannot be towed prior to your possession of the unit being terminated. So like if they do have a judgment against you and about to get rid of possession, they might have a right to tow it. But if they have not been given permission back from the courts that they have a higher right to possess that unit, they cannot take it out on your vehicle. No.
So that's what's the retaliation thing? Is that a form of retaliation?
It wouldn't be, because I've only seen the law, I haven't seen it played out in like a tow hearing when it's in this scenario. I actually need to go look and see if there's case law behind it. but it wouldn't be considered retaliation per se. It's just the fact that there is a law in the Texas Property Code that says that if your car is following the lease, like I said, it's permitted, it's running, and it hasn't violated anything, then they can't just tow it simply because.
Gotcha. What circumstances would a landlord be allowed to take certain possessions, and what possessions could they actually take out of someone's unit?
So this is also governed by the Texas Property Code. It's called a landlord's lien. If you have language like that in your lease, it'll tell you exactly what is exempt and non-exempt property that the landlord can take if you are behind on rent, without it being conversion. But it will be outlined in your lease, and they're also in the Texas Property Code. I can make sure to add a slide if for next time.
So as boring as it may be, everybody needs to read their lease, even, all
Yes.
15, 20 of those pages or whatever it is, all the little fine print, you gotta read it.
Yes, because in certain circumstances, some leases might literally say, if it's not your work laptop and you owe us money, we never have to give it back if you don't pay us. It's a lien, right? Like I'll go and sell it and put it towards your balance. And you don't want that, if you don't have to. And so definitely want to read your lease to understand exactly what you have a right to, but also what your landlord has a right to do with your property.
Hmm. I've seen in some instances too, like during, damages for a storm or some repairs or something like that, that a property management company does for like storage units and things, and then they move people's things. Are they allowed to just kind of, okay, well, we've got some renovation or some construction that's due on X date. If your stuff is not moved, can they physically move your possessions somewhere else?
Also, check your lease.
Check your lease.
Because if it is for bona fide repairs, if it is for an emergency and they provided you with notice, and it's like, you know, if you don't want to move your stuff, we have to move it. There might be language as to how they move it and what they can do with it. And that's what you'll want to know, is that if they do move it, do they have a duty to protect it? Are they gonna leave it outside? Like, and because that's gonna tell you what you're allowed to do and what they're not allowed to do. So I also say that if you move into like a single family house that you maybe agreed to do renovations on, or you already know that there's gonna be fixes that already need to happen, make sure you have in writing exactly that situation. In a scenario where I'm not home and didn't receive notice, or you need enough notice to move your belongings before your landlord can touch it, get all of that ironed out ahead of time.
When you just mentioned renovations and things like that, and I'm if someone moves into a single family home and landlord, property management company, whomever says that they will fix, they will repair, they will replace or whatever, the tenant moves in, but none of that stuff is still ever done, is that grounds for them to then say, hey, you didn't give me what I was supposed to be getting for the amount of rent that I'm paying, so I'm leaving?
So I would say, one, if ever that happens, get it in writing. Whatever
Mhm.
they promise you or whatever repairs they promise, you want to also get in writing what happens when they don't do it. Because my general advice from friend to friend is don't move in. Like there's
Wait,
like if
wait
they
until
say
it's
that they'll get
done.
you, yeah, if they say they're gonna get you a new refrigerator or a new stove, as soon as you move in, that might become a lower priority to them. So, you can say, well, get the stove, get the fridge before I give you a dime before I move in. So that's just friend to friend, don't do it. But if, because life happens, things happen, and situations, sometimes it might be a really good deal. You're going to want to have something in writing saying, I don't have a fridge. The floor needs this, or the back door needs this. And if it's not done by this time, this is what will happen. So now you're not withholding rent. You're doing what was agreed upon. Now you're just enforcing a contract, and that gives a different connotation. So if you are in that situation and find yourself being like, I have to move in here, you know, the second toilet, because you might have one working bathroom, but not another one. Make sure you don't just put in your lease, will fix toilet, because yeah, I will do it. You want to make sure that there's
A
something
timeline
that,
too.
yeah, time of the essence type of language so that you don't end up hurting yourself while just trying to, you know, thinking you're doing, oh, it'll be fine for a couple weeks, but it's not going to be fine in 6 months, and you don't want
Yeah.
someone telling you you have a bathroom. What are you complaining
Or
about?
or I said I'll fix it. I didn't tell you when I was gonna
It
do
precisely.
it.
Mhm.
Gotcha. Gotcha. Okay. Can my landlord come into my unit after giving me an MTV, a notice to vacate, just to come in without notice?
Most leases do allow for a landlord to drop by at any time for reasonable business purposes. Most leases say that. You definitely want to check your lease. All permissions, everything a landlord and tenant can do needs to be in your lease. So you want to check that first. But yes, your landlord generally does have a right to enter the property, especially like if you live in an apartment complex after they give you a notice to vacate their business purpose. I don't want to say quotes because it also is true. If they gave you notice for 3 days, maybe on the fourth day, they just barge in and they're going to claim, oh, you were supposed to be out yesterday. So my business purpose for being here was to check if you're still here. So you definitely want to note that. And also, if you're at home, use a security lock. Get that second lock turned on if you're ever at home and you're nervous, because some landlords can become obnoxious once the eviction process starts. And I have heard stories where they'll come by every day and it'll feel like harassment, but as long as they're providing you with certain notices, they might actually be well within their rights to do so.
What if there is no notice to vacate and then they're just kind of coming in? What's their right as far as access, even if it's reasonable business purposes, just coming in? Are they supposed to give you notice then in that regards?
So I'll give an example, like my lease, I believe, says that they have to, if they're gonna come in unannounced, they have a right to come in unannounced as long as they leave notice on their way out. So that's like, for example, what my lease says. And then there's if they're going to come in without notice, it has to be for reasonable business purposes, and they have to leave a notice letting you know they were there. So every lease is different. So it's, for example, so as far as I'm concerned, if I don't want them barging in while I'm here, I have to keep both locks on. Otherwise, do they have a right to kind of come in? I gave it to them in my lease. So yeah.
Oh, okay. All right. Kind of going through the chat here to make sure I've got everything. In what circumstances would someone contact, no, let me take that back. After some type of a disaster, it's been raining, it's flooded, you now have mold, or something's not remedied, could you then, contact the health department or contact the city, or like what are your options in that regards? Are they required to put you into another unit, or are they required to remedy whatever the mediation that needs to be done to fix whatever the problem is after a flood or after some kind of a disaster or fire or whatever?
I'm gonna say it one more time.
It depends.
It
It
does depend.
depends.
It depends on your lease. And it depends on the state of it. So like I was like the example we gave, if you have a partially usable unit, you will have to go to court for them to establish what usable is, what that looks like, if it needs to be terminated, if you can reduce your rent, all that. Um, your rights begin immediately. Like if you have any damage, of course. As long as you're up to date on rent and you don't owe anything, then your right to repairs always remains. However, if there's extensive damage to the point where your landlord has to deal with insurance, you might not get a repair right away. They might, because they have a right to contact their insurance, wait for an agent to come out, do the claims, get the claim money, and then make the repairs. And so in that sense, you definitely encourage people to get on it as soon as possible. So you want to get all your pictures and everything to your landlord as soon as possible, because if it is something that they would have to go through insurance for, they can delay the repairs because of that. And if they do have to, there are laws and ways through your lease or through the property code, for example, that might allow you to terminate your lease early without penalty.
Okay. Another question here. So we talked about leases and the TAA lease is very pervasive. What would you change slash negotiate other than the amount of the rent in the standard TAA lease? Are you allowed or are you allowed to make changes in a TAA lease?
My argument is yes, you can. I think it just depends, I think, on what you are trying to change. Um,
And if they agree to it.
yeah, because for example, if you live at a large complex or one of our, you know, Gray Stars fee and all those things, the bigger ones, they probably don't give their leasing agents um room to negotiate certain things. Um, for example, like she's like the question we got before, I don't, if you have kids, for example, or if you work from home and you say, okay, the lease says that you can come in anytime for business person, but leave a notice, but I need notice ahead of time because I work overnights and sleep all day and I don't want to wake up to a knock, knock, knock. I must come in now. That might be something you say, hey, can we add that you must provide notice 24 hours ahead of time? That might be something that makes sense for you and isn't going to cost them anything to put a notation in your file, provide notice prior to going to her home. So it's things like that. It all pertains to your life, your lifestyle, and what you would need from the lease. But for example, that would be something that's really what's in mine. Like my notation in mine is that I work from home, I work remotely. I can't have people just knocking without my notice. And so that's like one of the examples. But I would look through it and see, yeah, what works for you.
Said another way, what are the most glaring evils in a TAA lease? That also depends, I think.
Yeah, well, me, I don't like hidden fees. If they, they can throw certain things on your ledger, so you want to make sure you understand how like your admin fees are totaled. If it's a percentage of something, you want to know. That's really the worst ones. Yeah, attorney's fees, any type of eviction fees. Some of them have like if they send you a notice, if they mail it, they charge you a fee. I'm like, read through it and get to crossing out the ones that don't make sense. Um, Let me think. Hidden fees are always the most nefarious to me. And also the entry into the apartment. Those are the ones I kind of really look into. And notices of a breach. You definitely don't want them to sneak something in as like if you have children, if you know I'm moving in with 6 kids and noise complaints is going to be a breach, you might want to, discuss that further and say, you know, what does that look like? What do those notices look like? What am I allowed to do, not allowed to do? Things like that. But yeah, I think it all depends. But there are some hidden things in there that you definitely want to comb through and get to highlighting.
So speaking of fees, since she just brought that up, is a landlord allowed to say my rent is $1,000? And I know there's nowhere that you can find rent for $1,000, first of all. So I'm just kind of throwing a number out there. Your rent's $1,000, and I'm only giving you the option to pay online by check or card or whatever. But by paying by check or card, there is a fee of a certain percentage, or there is a $20 fee or something to pay the rent online. Then technically my rent is not $1,000 if you're making it mandatory that I pay this fee in order to pay the rent. Is that legal?
If you agree to it, it is. If you agree to it, it is. But you, that's a good question. If it's in your lease, yes. But if you catch that, right? If you're signing your lease and you catch like, oh, wait a minute, I know that this place charges $20 to send money. What is my fee list option? You know what I mean? Like that's when you get in like, can I Zelle? Can I bring cash? Because there should be a feeless option so that you're not because just like we're allowed if we pay by card, it might be a 3% fee, but if you pay by ACH direct wire, it won't be a fee. Things like that. You definitely want to make sure, and I believe there's something in my gut that tells me there's probably a consumer protection that let me write that down, look up. Um, that states that they have to give a feeless option.
Option. Okay, that was my next question. Are they required to give you options and not just make it mandatory that you only have that one form of payment?
Mhm. I believe so. I want to double check that to be sure. We do have our litigation director also does consumer, so I will ask and see what that looks like actually.
I want to double back on another question that I had before I get to this other question that's in the chat. We talked about like a disaster happening, a fire or flooding or anything like that, and then they offer to move you into another unit or a unit that has now been upgraded. Are they allowed to charge you the upgraded rent or change the whatever the fee amount would be for that rental unit when you were paying something that's lesser, but only what's available is something that's more expensive? So if my rent's $1,000 and you move me into a unit that's 1,200,
I'm
I'm
gonna
not
look that one up too, because
okay.
that's a good question. Um, and I feel like I used to know the answer. I don't believe they can if you have the ability to terminate your lease. So usually because you have a right to terminate and you don't have to move into the other unit, then I believe that they can raise the rent. But but the caveat is the fact of the damage to the original unit. And so that's what I would have to look up. Is it the fact that your other one is damaged? I don't believe there's anything requiring a landlord to move you just because
Right.
but I'm gonna look and see what that triggering event would be.
Okay. All right. The question here is, what about mandatory arbitration clause in senior living lease? Is it allowed?
Mandatory arbitration clauses are allowed, hard stop. I don't think that there's a carve out for senior living places. I would have to look into that. But mandatory arbitration clauses are enforceable.
Does that answer the question? Because I was kind of, the question is a little, I wasn't sure about. Okay, yes, he says that answers. Okay. All right, great. Um, and there was another question that I had. Oh my gosh. And I forgot just that fast. Uh, basically don't agree to it. Is that what that means?
If you don't want to do it, do not contract to it.
Just say no.
Just say no, because I feel like everyone has to really understand that once you sign on the dotted line, there's no more
You're
argument.
agreeing.
You're agreeing to it. So I can understand how we always feel like, well, I had to say yes to the terms and conditions. Yes and no. You could also not use the app, So it's always being very careful that don't let someone tell you, oh, we never do it. We usually, or they're never going to do that. No, if it's in writing and your signature's on the line, that contract as it stands can be enforced.
So what happens if you are in a situation where you are due to move in, the unit is all set where you were supposed to be or whatever, what they showed you, this is the unit where you're going to be, and then you get there, it's time to move in, it's time to sign, pay your money, get your keys, and oops, sorry, no, we're not moving you right here, we're now moving you right here, or you know this was available but now it's not available anymore. What's the right as the tenant that's supposed to be moving in there? Again, either you agree to it or you don't, but the position that puts you in, is that almost like, almost like bullying you. Like either you take it or you don't. And then now I'm stuck without having a place to live because this is where I'm supposed to be.
And
But
the really sad answer and truth to that is that happens. And
yeah.
if you don't want to be there, do not move in there. Because once you take that possession, you essentially like agree, you acquiesce to everything. If you have to pivot and find somewhere else to live or end up in a hotel or anything like that, then you can look for an affirmative lawsuit. It's not a quick fix. It's not going to get you the unit you asked for. It's not gonna affect your today. So that's why sometimes civil lawsuits and enforcing your rights is not an everyday, it's not an immediate case, but you do have rights if that does happen. There are consumer protections. If they promised you a unit, you signed the paperwork, you gave the deposit, and then they're like, oh, never mind. There's very certain circumstances in which they can renege on their end. So you definitely want to don't move in, don't agree. First of all, I wouldn't move anyway because you don't want to live at a place that a landlord behaves like that because that's the lowest bar. Give me the apartment you promised me. That's the lowest bar you could, deal with. So I wouldn't move in. But yeah, if you do incur extra costs, if it ends up being a hardship and you have actual damages, then yes, I would seek legal advice and legal assistance to see what type of if there is a way for you to recover on any damages that might have caused.
Okay. I got two more quick questions that just kind of popped up into my head real quick. One is, and it just popped away just that fast. Oh my gosh, getting older is just no joke. My sponge is full, stuff just starts leaking out, and I can't remember everything. Um, oh my goodness. Oh my goodness, it's gonna come back to me. It's gonna come back to me. And I don't want to monopolize. If somebody else has another question, then please make sure that you ask. That's what it was. Termination of leases or subletting. What's the rule, or is there a law or a rule about subletting? So if I'm 8 months into a 12-month lease and then I now have to move, or I've fallen on hard times, or job relocated, or what have you, am I legally responsible for that other 4 months rent, especially when the landlord is just going to re-rent that unit?
Okay, so what you're describing is early termination of a lease that's terminating during the initial lease term. Now, some leases, I'll even say I don't even think a TAA lease allows for subletting. But if your lease allows for subletting, then you need to follow what your lease says and work with your landlord because most times, depending on the type of complex it is, you can't move just anybody in there. They want to run their own background, or they'll consider it. We'll just have that person as a leaseholder. You have to terminate and pay the penalties like that. But absent those circumstances where you can terminate early during the initial term period without penalty, you'll always suffer a penalty if you leave early. Without consent and even with consent, they could still charge you a reletting fee, or because that is essentially like a liquidated damage to a certain extent. But they do have a duty to mitigate. So yes, they will put somebody else in the unit, but if you agreed in your contract that if you terminate early, this is what happens, then that's going to happen unless you get into another agreement in writing saying that you can terminate early without penalty.
So is the reletting fee a particular dollar amount, or is the reletting fee the amount of the remaining balance of the lease?
Depends on your lease.
Depends.
Because these are the law isn't gonna, we're in Texas, the law isn't gonna give you so many rules on how an owner can use their land and what an owner can do. So you're not gonna get very many laws that restrict the owner. The only way you're gonna restrict the owner or create rights for yourself on someone else's land or on someone else's property is through your lease. So you wanna be know yourself. If you know you want to live abroad, if you know you're going to travel abroad in 6 months, don't get a 12-month lease. Don't. Like, oh, it's going to be more expensive. You're going to pay the same cost by signing a 12 one and trying to terminated early or illegally subletting and suffering penalties on that end. So know yourself, know your plans, and yes, I want people to go into these leasing offices, and no matter how typed up that sheet of paper looks, understand that you can ask questions. You can be upfront about what you plan on doing, what you can do and can't do, and make edits to that lease, as much as you can. Because
Mhm.
it's really the only way to avoid penalties, because these penalties are usually built into most residential boilerplate leases.
Okay. All right, whatever that other question was, if I think of it, I'll send you an email or
Yeah,
something,
you
or,
know where to find me.
I can't quite remember what it was, but I'm sure to come to me as soon as I end this presentation. But um, one thing I do want to reiterate from our conversation earlier, please communicate with your landlord, your property management company about whatever the financial situation is that you may find yourself in, uh, to help, avoid anything related to eviction or you becoming unhoused or anything like that. So you don't want that to be the end result. Definitely communicate with them and have the conversation. Find out what your options are, because if you don't ask, you don't receive. So ask them, can I make a partial payment? Hey, ask them, can I go into a payment arrangement? But definitely have the conversation and know that the notice to vacate is the start of the eviction process, but not the notice, is not the actual eviction in itself. I've gotten so many people that just think, oh, I only got 3 days to move. I only got 5 days to move or whatever. And they just think, okay, I got to find some place to go in 5 days. And that's not the case. So, definitely make sure that you reiterate that, as well as read the lease, as boring as it may be.
Yeah.
Do a
Because you don't
paragraph a
even
night or
know,
something,
you
whatever.
honestly don't know what you're promising. It, Something serious could be hidden on page 8, and you read through page 4, and there's nothing you can do about it, because once you sign on the dotted line, if you try to enforce a right that you've already waived, you might be stuck, and it'll be the
Indeed.
worst ones. So, yeah,
Indeed, indeed. So I'm trying to watch social media too at the same time and make sure I don't miss anything in case somebody's got a question there. But I don't see anything here. Well, with that being said, thank you. It's been great. One of the best examples is the death clause in a TAA contract.
I'm pretty sure
That's a
it
good
looks
one.
nasty. I'll look at it.
That's a good one. That's a good one, because you've heard of people that are still where the landlord or the apartments will enforce or try to enforce a contract with the estate even after someone has passed. Like,
Yeah.
they're gone. Who's gonna pay that?
Yeah, yeah, that's why read it well. So,
Yeah, that's something I've never understood. And then the same thing with the eviction or the leaving or terminating early. If you're charging me the fee, but you're gonna re-rent that same unit, isn't that double dipping? Like, you're gonna charge two people for the same unit twice, But at any rate,
yeah,
um, thank you again, Ms.
happy to
DK.
be here.
Wonderful conversation today. We definitely appreciate you and the services of Lone Star Legal Aid for having you here this afternoon. Again, do not discount yourself and automatically assume you will not qualify for services. So please reach out if you do find yourself in need, or if you are facing eviction. You want to be preemptive when you're facing any kind of financial hardship or the potential of becoming unhoused. You also have the opportunity to reach out and to find rental housing counselors that are in your area. If you go to hood.gov, you can find a housing counselor that also does eviction, rental and rental eviction prevention counseling for you. So again, communicate, have the conversation, find out what your options are, and ask questions, ask questions, ask questions. So if I always tell my real estate clients, if you find yourself dealing with somebody that doesn't want to answer your questions, then that's probably, a good sign that's this kind of service that you're going to get later on. So if they don't want to answer, you know,
Yep.
take your funds elsewhere. So again, thank y'all very much for joining us and for tuning in. A link of this recording will go out along with some available resources and links and websites and things like that that you can go to, in addition to the website for Lone Star Legal Aid for you to apply for their services as well. Again, the link for the survey is going to pop up on the screen after you all log off. Please take just a couple of minutes to kind of go through and provide us with that evaluation, fill out that survey to kind of let us know, if the information that you heard was beneficial, what was most beneficial to you, was it helpful, was there something missing? Is there something more that you want? If there's another issue that you're facing that we don't know about, then definitely let us know. So again, as we're scheduling future presentations, we'll know what to provide to you guys, or what's available, or what's pressing to you and to folks in your community. So definitely let us know. With that being said, thank y'all very much for joining us. You all have a wonderful remainder of your day. If there's more information that you'd like to hear or questions that you think about next month, we are here the third Tuesday of each month with this eviction presentation. So you have the opportunity to come back. Again, things change, processes change, laws change. So we want to try to bring you guys the most up-to-date and most accurate information from the volunteer professionals that are here to provide that information for you. So as much as I kind of think I know, somebody definitely knows the most accurate and the most accurate way to tell you, or to kind of educate you on those processes. So feel free to come back and join us anytime. Look us up on our YouTube page or social media on Instagram, Facebook, and follow us and let us know what's going on and what's important to you guys. So thank y'all. You all have a wonderful remainder of your day. It's supposed to get cold later on this week, so be careful, be prepared for this little freeze or this winter, whatever that may or may not be coming. Depending on the day of the week and which channel that you're watching at the
Check
time.
every morning.
Yeah. So you all stay safe. Enjoy the remainder of your day. Take care of yourselves, and we will see y'all next time.
Thank you
All
for
right.
having us.
Bye-bye.
Bye.